Okay, we are going to go ahead and get started. So I am very, very pleased to have Hopkins and Huebner here today, and they were selected through our RFP process. But as you can imagine, with COVID, we had to go back to our top 5. It has changed everything, and they are just a wealth of knowledge in what is happening in terms of employers for COVID. So I'm excited to introduce Hugh Cain. Hugh, if you can wave, they know who you are. Brent Hinders and Eric Updegraff. And all of these gentlemen are with Hopkins and Huebner, and they have a wealth of knowledge. They have over decades. Altogether, I can't remember how many years it is of knowledge that they have, but they are always great. They've been at the summit before. And I honestly am not going to waste any more time. We're going to go ahead and get started. Just a few reminders. Please make sure your microphone is muted, and please make sure your cameras stay off so that we can save bandwidth. And then if you have questions, they are willing to take them throughout. So please go ahead and type those in the chat function, and then I will announce those to them, and they will answer as they go. So gentlemen, I am going to hand it over to you, and you are free to go.
Thank you, Christina, and thank you to the Greater Des Moines Partnership for having us this morning. We always love working with your organization and talking to your members about all these different issues. Just as Christina said, originally we were scheduled to do the 7 deadly sins of the employer handbook. However, someone opened one of the seals of the apocalypse, and here we are today doing the explanation of terms and issues of COVID-19, legal issues for employers, or as we have affectionately named it, exotic legal issues for employers. And of course, exotic brings to mind for all of us who have been alive, good or bad, for the last 5-6 months, our friend Joe Exotic of Tiger King. So Hugh's going to give us just a little overview of Joe Exotic, if you missed out on that, and then talk about something that's really important to the plot of Tiger King, family. So the Family Medical Leave Act changes that have occurred in the last 5 to 6 months due to the Family First Coronavirus Recovery Act. So Hugh, take it away, sir.
I always love the theme of family dysfunction. It's something that we all get to live with to an extent, and it goes back for generations. You've got King Lear with Shakespeare. In the 50s and the 60s, you have Peyton Place. In the early 2000s, you have Scott and Lacey Peterson, who only made the news again earlier this week. And then you have Joe Exotic. So the theme of dysfunction runs through all of this. And in terms of why we love it, what I think almost 35 million people watched Tiger King over the last 6 months. So things we all love dysfunction, which sort of takes us into the Family's First Corona Act, which went into effect on April 1. It was passed just a few weeks before that in mid-March. It did a couple of things. It impacts all businesses that are under 500. So if you've got 499 employees or less, you are covered by the FFCRA. And there's 2 provisions that are important for businesses there. And those are the expanded sick leave and the expanded Family Medical Leave Act. The other thing that we're not really going to talk about but exists is there are tax credits that can help you fund at least a portion of it. And you need to talk to your finance or your tax folks regarding those. But let's talk about expanded sick leave first. As you probably all know, prior to the COVID era, Family Medical Leave Act existed, but it only applied to businesses that had 50 or more employees. And it was all unpaid leave. That's no longer the case with the expanded Family Medical Leave Act. The expanded Family Medical Leave Act applies to any business that has under 500 employees. It also impacts any employee who has been there for 30 days. So you don't have to work like the old FMLA. You didn't have to be there a year and have worked 1,250 hours. You only have to have been there for 30 days or more. And then there is a formula for how much you will receive under the Expanded Family Medical Leave Act. The Expanded Family Medical Leave Act only has 2 requirements. There are only 2 times people can take Expanded Family Medical Leave Act. First is if your school closes due to COVID, or the second, if your daycare or childcare closes due to COVID. So it's not because you have COVID, that you are sick with COVID, or that you're caring for someone with COVID. Family medical leave expansion only applies in those 2 circumstances. That is, your school is closed or your child care provider is gone due to COVID. Those are the only 2 reasons. The other thing that you should keep in mind, which goes back to the theme of dysfunction, is that an employee has to certify in his or her paperwork that there is, quote, no other suitable person to watch Junior or watch the child, and that he or she has to take it because there's no other suitable person. I spent the last 6 months fighting that battle all the time regarding, quote, who is a suitable alternative to watch Junior? And the answer is, you as the employer have no ability and no right to say somebody else should be watching Junior. That's not what the regulations are going to provide. The regulations, in effect, make it the determination of the employee and the determination of the employee alone as to whether there is a suitable alternative person. So for the last 6 months, I've had an employer who desperately wants the employee's live-in companion to watch the kids because she's home and she's unemployed. But the father of those children keeps saying she is not a suitable person to watch his children, which I love the idea that they are sharing a home, but she is not a suitable person. And he's right. It is not the employer's choice as to who is suitable and who isn't suitable. It is the employee alone who gets to make that decision. So if you're eligible for...
And Hugh, one question that we've had before is, well, what happened to the old FMLA? What about the original FMLA that we've loved and embraced since the 1990s? Did that change? Is that still in place? What's going on there?
The old FMLA is still in place. And again, but it only applies to those who have 50 or more employees. One of the things that coincides between new FMLA and old FMLA is you only get 12 weeks total for both. So for instance, if you took FMLA in January of this year because of a serious health condition for you, your spouse, or one of your children, you have run out of FMLA. And you don't get new expanded FMLA for school closure or daycare closure. So all of the old FMLA is still in force and effect. It is only that there are now 2 additional reasons that you can take FMLA, which is the child care close and school closing. Now, the other difference between the old FMLA and the new FMLA is that the new FMLA is paid. The old FMLA, as you all recall, was unpaid, though you could require someone to substitute paid leave. So under new expanded FMLA, you would get 12 weeks of leave, just like the old. The first 2 weeks are unpaid. That is, there is $0 that the employer pays the employee while they are on expanded FMLA leave. The caveat is, and we'll talk about this on when we get to expanded sick leave, is there may be expanded sick leave that you have to pay for those first 2 weeks. The second portion, that is the last 10 weeks of the FMLA, of the expanded FMLA, you pay 2/3 of the employee's regular rate, and you use the number of hours that they're normally scheduled to work. So if they're full-time, it's 40. If it is a part-time employee who normally works 20 hours, then they get the equivalent of 2/3 of 20 hours of their pay. But there's a cap, and the cap is $200 a day or $10,000 aggregate. If the employee so wants, they can supplement the 2/3 with other paid leave, which of course becomes sort of an accounting problem, but it's the sort of thing that somebody can figure out. There are also a couple of other important caveats to the expanded sick leave. It applies to public employers and private employers, but there's a couple of opt-outs. There is an opt-out for a healthcare provider, and there's an opt-out for an emergency responder. So if you're a city or a municipality, you may decide that your public works department, which is now defined as an emergency responder, is opted out. And if you are a doctor's office or a healthcare clinic or a hospital, you can declare that your entire workforce is opted out. Because under the new definition of healthcare provider, under the new expanded FMLA, it includes everybody who works there at the hospital. It includes secretaries. It includes the billing department. It is not just folks who provide healthcare services. Now remember, that's different than the healthcare definition under the old FMLA, which basically is you had to be a licensed professional in order to be a healthcare provider. The other sort of opt-out that exists is if you are a small employer of under 50 employees, you can opt out if some senior manager, likely a CEO or the president of the company, certifies that it would jeopardize the business as a going concern to provide expanded sick leave and expanded FMLA leave. So those are ways that you can opt out if you so choose. And the final thing I just point out to you on expanded FMLA leave is, if you remember from old FMLA, an employee could take it intermittently. That is, you could take 2 weeks here, work for a couple of weeks, take another 2 weeks later on. That still exists under expanded FMLA, with the caveat that both the employer and the employee have to agree to intermittent leave. So if you're an employer, you can decide and say, I'm not going to allow intermittent leave for expanded FMLA leave because it's too hard for me to operate. And that's perfectly fine. That then takes us over to, on that theme that all old things are new again. So family dysfunction has been around for a long time. So have shortages. And one of the shortages that we all know that happened early in the epidemic was toilet paper. Well, I'm old enough to remember waiting in gas lines in the 1970s during the various and sundry oil shocks. So shortages don't seem to be anything new. They are just the old things that are reappearing. What's odd about the new shortages with toilet paper and paper products is there's always been enough. That's the shocking thing. It's not like Kimberly-Clark stopped producing paper goods in March and April. It's just, we all want to have something in our back closet or our garage in case of an emergency. So in terms of old is new again, the idea of requiring paid sick leave by employers has been around for decades. And finally, it has come to pass in the FFCRA. So under the expanded paid sick leave, there are now requirements for an employer to provide up to 80 hours of paid sick leave under certain conditions. The important thing to remember is that expanded paid sick leave is in addition to any paid sick leave that your company provides, and the expanded paid sick leave is first payment. So the first dollars that you pay out on paid sick leave are under the expanded paid sick leave, and you do not get credit against any of your currently existing employer policies. The other thing is, it applies to any Tom, Dick, or Harry employee on their very first day of employment. There is no 1 year requirement. There is no requirement somebody work for you for a month or a week. Expanded paid sick leave entitlement starts on day one. Good news is, an employee only gets it once. So if they take it from employer Smith Inc. In April, and then they change jobs in September, they only were entitled to the 80 hours of paid sick leave once. They don't get it twice. So under paid sick leave, there are 6 reasons why you can have paid sick leave. And they're important to keep them in 2 categories, and I'll talk to you in a minute why that is. The first 3 categories deal with the employee, him or herself. So if category 1 is if the employee is subject to a quarantine order. Secondly is if the employee, him or herself, is advised to self-quarantine. Or the third reason is if the employee, him or herself, has symptoms of COVID and is seeking a medical diagnosis. Those are the first 3 reasons why paid sick leave is available. Then there are a second set of 3 reasons. They deal with other people. The fourth reason is if the employee is caring for someone who's been advised or ordered to quarantine. The fifth reason is if the employee is caring for a son or daughter whose school is closed or whose daycare has closed due to COVID. And then the sixth reason is if the employee is experiencing something in a similar condition that the Secretary of Health and Human Services has said you should consider, like COVID. Good news for all of us is number 6, there are no regulations. There's nothing so far where the Secretary of Health and Human Services has applied these requirements to any other disease. If you take, so why that's important, you categorize these top 3 and the bottom 3, is if you are caring for yourself, that is, if you yourself have COVID or you are quarantining or you have symptoms of quarantining, then you get your regular rate of pay. That is, you get 100% with a cap of $511 a day, or a total of $5,110. Now remember, it's for 80 hours if you're a full-time employee. If you're a part-time employee, it's for whatever your regular hours are during a 2-week period. If you are taking sick leave for those second set of reasons, which is to take care of other people, then you only get paid at 2/3 of your regular rate, and the cap is $200 a day or $2,000 aggregate. So let's skip back to expanded Family Medical Leave Act. Under expanded Family Medical Leave Act, if your child school is closed or you've lost your daycare and it's due to, and that qualifies under Family Medical Leave Act, The first 2 weeks, the first 80 hours, you pay at 2/3. Other thing that's important is you just can't be a complete good Samaritan. Condition number 4 that says you're caring for someone who is ordered to quarantine or has COVID. It's got to be somebody you've got a pre-existing personal relationship with. You just can't pick them out of a hat and say, this is the guy that I want to take care of. You also have the same opt-out provisions for healthcare providers, for first responders, and for very small employers. So that, folks, is the expanded healthcare and FMLA lead under the FFCRA. And now I'll turn it over to one of my partners.
Well, the next step on our COVID odyssey, after we hoarded toilet paper and then all watched Tiger King, was that the rise to national prominence of Dr. Anthony Fauci. I think we're all familiar with Dr. Fauci now. He has been the director of the National Institute of Allergy and Infectious Diseases since 1984. He's served.
Can I jump in with a question real quick before we move forward?
You bet.
Kind of on the last piece. So
Go
it
ahead.
says, what do they mean by quarantine order? Order by the doctor or per employer's policy?
Well, it's technically not defined. So it can be either a governmental order. So for instance, the governor, the head of the county health board, that could be a quarantine order. I don't think that a quarantine order is an employer's order. However, it is likely it could come in under 2 and 3, which is a healthcare provider has advised the employee to self-quarantine. So if my law firm tells me to self-quarantine, all I have to do is go to my tell my doctor, and now I've been advised by my healthcare provider to self-quarantine. Or if I'm actually exhibiting symptoms, I'm going to be covered.
All right, so carrying on then, obviously our next portion of these slides are all inspired by Dr. Fauci and his work on the coronavirus and talking to each other. The first thing I wanted to talk to you about are temperature scans. So one of the questions that we have been getting from employers is, can I require my employees to take temperature scans before they come in? Or can I require temperature scans before I let people into a public building? And here are the answers to those questions. The first part of it is that the EOC says that a temperature scan is a medical exam under the ADA. And what that means is that the ADA sets out this concept that you can't ask for medical information from your employees simply because you want to be a voyeur. Just because you want to know what their medical condition is or what the deal is, you're not allowed to ask that. Now, if you have a business reason, if, for instance, in this case, you have people who are going to deal with the public and may, in fact, infect the public with COVID if they have it and you don't know, then you can ask for a medical exam. And so it fits into the existing framework. We always talk to people about the ADA with things like, I have an employee, they're injured, they want to come back to work, I'm not sure that they can safely do it. Well, in those circumstances, you can often ask them to go to a physician, have a medical exam, and determine whether or not they are fit for duty, whether or not it's safe for them to come back to work, those types of things, in a manner that is related to your business. But you can't just do that to anybody, because that's how you discriminate against people with disabilities. The idea being is that if you start asking for a medical exam of people because of your bias or perceived bias about their disabling condition, you violated the law. So the question that you have is when you have temperature scans is, how do you avoid that? Well, first, figure out what is your business necessity. I mean, if the idea is that people are going to come into your workplace and you're not really sure that they'll be able to safely social distance, they don't all have separate offices, they have to share common areas, that might be enough to be a business necessity. The second part about it that you have to consider is, what do you want to, why is it that you want to have, how much of a medical exam do you want to have? In particular, a medical scan or a temperature scan is not a particularly big deal, but you want to make sure that you are using that temperature scan in a even-handed fashion. For instance, one of the things that people get in trouble with is that they start looking around the office and they start looking at old people. They start looking at people who are in bad health. And if you only require people who are old or in bad health to take temperature scans, you're going to violate the law. You're going to be discriminated against them based on their age. You're going to be discriminated against them based on their disability or their perceived disability. Because even if they don't have a disability, but you treat them like they have a disability, you've potentially violated the law. So if you're going to have a temperature scan, one, make sure that you've got a business necessity for doing it, that there's going to be exposure either to the public or other workers that requires a temperature, that you have a temperature scan. And number two, make sure you do it in an even-handed manner. If you require everybody who is going to deal with the public to have a temperature scan, you're going to be just fine. If you require everybody who's going to be in close contact with other workers to have a temperature scan, you bet. All right, number two may not, back up, sorry. Number two may not apply to all of you, but one of the things we got asked about was, what about government entities requiring a temperature scan before you can come into the building? In particular, there was some discussion about whether or not everybody should take the little temperature gun and scan you. Maybe you've had it happen to you. I know I've seen it in a number of places where they do that for patrons. And the issue is yes, you can require a temperature scan. The Eighth Circuit Court of Appeals talked about something similar in the Rutledge case when they talked about, and Rutledge is an abortion case. And in Rutledge, they're talking about whether or not you can require somebody to test negative for COVID before you give them an abortion. And of course, I believe Rutledge is an Arkansas case. And in Arkansas, they said that the ACLU, I believe, challenged it and said, no, well, this is really designed to prevent abortions. Of course, the doctor said, no, we don't think we should be giving abortions to people who have COVID because there's a real potential for harm to them if we do so. The Eighth Circuit Court of Appeals took it on, which is the court right below the United States Supreme Court for our area, took the case on an expedited manner, and in the fall decided, yes, you can in fact require people to, in fact, have a negative COVID test before you provide them medical procedures. What they discussed there is the very basic concept of the police power. So if the government tells you you can't come into the courthouse unless you have a temperature scan, there are competing constitutional rights there. There's your right to freedom of association and essentially access to the building versus their police power right to make sure that people are safe. My guess is that the Eighth Circuit would come down on the side of allowing a temperature scan for purposes of that police power. Now, what I would tell you there is that means that you're probably in pretty good stead if you, as a business owner, want to require your patrons to have a temperature scan before they came into your business. Because you're going to be able to say, well, one, there isn't a right of freedom of association because your property is private property and therefore not subject to the constitutional right of freedom of association. And on top of it, you're going to have a health and safety reason to do it. In the law, health and safety is the number one and most powerful justification for doing anything. All right, so then we want to talk to you about this more as general information than anything else. But they talk about there are CDC guidelines on this, and it talks about do you feel compelled to have a temperature scan? I mean, and one of the things that we then get asked about people when we talk to them about temperature scans is, well, does that mean I have to do this? And the answer is no. What the CDC guidelines say on this is that schools are not required to do such screenings. They do not. When they talk about businesses, they refer you to the school rules for some reason, but that's how it was set up. Apparently they didn't want to copy and paste them, but that's what they did. And from that perspective, you are not required to have a temperature scan for your employees. You're not required to have a temperature scan for your patrons. You can if you want, but if you're going to do those screenings, you have to pay attention to what we talked about before, making sure you're doing it in an even fashion. All right, so then I'm going to talk about this one just briefly because Hugh talked about it earlier, is that if you happen to employ healthcare providers or emergency responders, they can be excluded from the EFMLA, the expanded sick leave, and the expanded FFCRA. In particular, as Hugh said, a healthcare provider is essentially anyone who works at a healthcare shop, all the way down from, from the surgeon all the way down to the receptionist, the janitor. Everyone in that organization could be told they had to come to work. And so in that circumstance, if that's the type of people you employ, you don't need to worry about EFMLA or EPSLA because your workers are exempt. And then the next one talks about if any of you, and I don't know that as part of a small business administration you are dealing with emergency responders. If you're employing them in your job and they leave elsewhere, they are also exempt from the EPSLA or the FMLA. So I suppose for your purposes, if you have an emergency responder as one of your employees, don't expect that they will be off work or have been off work as a result of COVID. They're exempt and they have to show up. All right, so the next one we're talking about is Zoom meetings.
Hey, Zoom meetings. So if this is your first one, welcome to modern life. Zoom meetings, obviously not the easiest thing, but it's become a great way to accommodate numerous people and the ability to really do work, carry on work in the current situation. And really telework has risen to the top of every employer's thought process on how, not only how to accommodate workers during the pandemic, but also how to conduct business in the future. So with that in mind, I'm going to talk to you about COVID-19 and really how that interacts with the Americans with Disabilities Act and some other acts. Of all the things that I'm going to talk about here are different recommendations that come out of the EEOC, the Department of Labor, OSHA, and even for the federal level, and even the Iowa Civil Rights Commission and the Iowa Department of Public Health. These are all different accommodations, different suggestions that they have told the public how it's best appropriate to deal with different issues during COVID. As I think Hugh and Eric have both alluded to, employers can only, in relation to COVID-19, employers can only ask any related symptoms of current or prospective employees. And for prospective employees, it's still that medical examination needs to be at the post-offer pre-employment medical examination stage, which has always been consistent with what the ADA is. So there's lots of employers out there, and you may be some of them, that have a checklist. Every day when the employee walks in, you might send an email that says, you have to answer these questions. Are you experiencing these symptoms? You can do that. However, bear in mind that that is a medical examination and it needs to be protected because that is protected medical information from your employee. So that, as Eric talked about too, that also includes if you require temperature measurement. All of those questions, that temperature measurement, any of that needs to be confidential medical information that all relates back. So if you're doing temperature measurement, do not do it in an area where everyone can hear you read off what someone's temperature is. Do not ask someone questions, the litany of questions about, are you experiencing these symptoms, in an area where other employees can hear the answers, because you are, as the employer, giving away confidential medical information that your employee is entitled to have protections for. Employers can send home employees with symptoms and require a doctor's note and or proof of negative test prior to allowing the employee back into the workplace. If the employee has a high temperature, if that employee does say, yeah, I am experiencing some of these symptoms. Our recommendation, at least thus far, has been we want a doctor's note and that negative test before you come back. Generally, the doctors, at the beginning, the doctors were saying, oh yeah, 14 days, he can't go back. Now doctors are saying, hey, if you don't have any symptoms, 3 to 5 days, you're fine, get back out there. I appreciate that doctors are comfortable with that, but most employers, and more importantly, most employees aren't comfortable. So I would just recommend that negative test prior to returning to the workplace. COVID-19 and reasonable accommodation. I think a lot of people lost their mind at the beginning of COVID-19 about, oh my gosh, reasonable accommodation, what's going to happen? How do we do this? Okay, so let's just look baseline at what the ADA says. Reasonable accommodation should be given to individuals who you either physical or mental. So if you have diabetes, you have severe asthma, you have you have COPD, that's likely a disability that will put you at greater risk with COVID-19. If you have anxiety, potentially if you have depression, if you have other issues that would mentally affect you, those are all things you can ask for reasonable accommodations during COVID-19 with that doctor's note. The other part is, what accommodations are we going to have to do? Well, right now we're doing an accommodation. This is a Zoom meeting. Telework, that's a great accommodation. It doesn't cost you anything. Actually, if you look back to the first slide, it's a free download and 40-minute use anytime you want to use it. If you're going longer than a 40-minute conference anyway, it should be an email. So Zoom meetings, telework, recognize accommodations. This is easy stuff. This is cheap stuff. One-way aisles, plexiglass, barriers to ensure minimum distance between customers and coworkers. We have one staff person here that just has a chair at their doorway to keep people out, and it says on it 6 feet distance. You already have this stuff, or you can go down to the hardware store and buy it at a minimum cost. So any concern about undue hardship, not there. Also, accommodations may be temporary in nature. I cannot stress this enough. Any accommodation you make for an employee ever in the history of your business should be documented. But it can be temporary in nature to the time of the pandemic, can include job restructuring of marginal duties. In fact, I think we're all experiencing some job restructuring of marginal duties anymore because we just can't do them during the pandemic. So our jobs are restructured insofar as it's not possible. You can transfer people to other positions, modify a work schedule. I think most of the law firms in Des Moines are still working on modified work schedule and shift assignments. So all of these things are things that we're doing. And again, those are low cost, so no undue hardship. COVID-19, the interactive process. So this is an interesting perspective. In a lot of ways, the interactive process can be waived. You can just skip to, this is what we can do, this is the best we can do. You don't have to have that long-term discussion. And the reason being is because if you have a long-term discussion and you keep an employee in the workplace that could be subject to COVID-19 and in dire consequences, you don't want to say, oh, I'll get back to you in 2 weeks. And after 2 weeks, oh, they're on a ventilator. I mean, that's why really the EEOC is saying, we don't have to engage in this interactive process over this long period of time. We want to help and save people. So that interactive process, I always talk about it as being a marathon. We don't even have to do the marathon anymore. We can just award the trophies at the beginning. But you have to look at the urgency of the accommodation, what needs to be accommodated. And you can do more really than you had to because it's a temporary basis now. Again, they need to be documented. If there's a limit in time, needs to be specified in the documentation. The limitation on time can be extended or changed based on government guidance. The CDC has changed things. The IDPH has changed things. I mean, literally things change week by week, month by month of what an accommodation should be, could be, can be. And even after this, you should take a look at those accommodations. Do we need to continue these accommodations? Is this an ongoing medical condition, disability that's going to extend past us that we should have been accommodating for? The other part is, don't forget about the people you were accommodating for before this. The big problem on accommodations is always that follow through and follow up. That just because you gave someone an accommodation 3 years ago doesn't mean that it's good today, and it sure didn't mean that it was good during a COVID-19 pandemic. So maybe follow up with those people. Are you doing okay? Is everything all right? Do we need to do something more for you? So always go back whenever you look at accommodation, look at revising and readapting those accommodations. We talked about we sort of talked about undue hardship. Undue hardship under COVID COVID-19 means, again, significant difficulty. Significant difficulty now isn't just how hard is it for you to do, put up the plexiglass, put up this, put up that. It's also, should you be doing this because OSHA says this? Should you be doing this because the CDC says this? And in regard to masks, because that's the question we get a lot of, can we have an accommodation where someone doesn't have to wear their mask in the workplace? Really? No. If the CDC says you need to wear your mask in these situations, and the OSHA says you need to wear your mask in these situations, you need to wear your mask in these situations. So the difficulty here is all in the view of COVID-19 pandemic and the different regulations. Also, significant expense. It used to be that, 6 months ago. So 6 months ago, if we had a case in front of the Iowa Civil Rights Commission or the EEOC, they would look back at our budget for 3 years and say, you could definitely do this accommodation because you could afford it. Doesn't mean that you have to, if you have to forego raises of the head honchos, you could afford it. You have to do it. They've taken a different tack now. They look at, okay, what's your budget look at now? Have you lost revenue? Have you lost income as a business? And the EEOC and the ICRC are at least ostensibly more forgiving that you can't, as an employer, afford some of these things now because you don't have the money anymore. Because remember, the U.S. economy shrunk by a third of its size. And so lots of people are losing a lot of money out there, hand over fist. So they look at your current budget. What's your budget? What's your budget projection now to determine that undue hardship? An employer may not consider different accommodations and standards for critical personnel or essential workers. So if you have essential workers, you have critical personnel, they can't get more than non-critical workers or non-essential personnel. They only get as good as anyone else. You can't treat those individuals differently just because of they're critical or they're essential, meaning that you can force them to go back to work if they're non-symptomatic. As stated before, employers can require employees to wear protective gear. Absolutely. We get that question all the time. Absolutely. You can require them to engage in and observe infection control practices. And in fact, those have become work rules, just the same as an OSHA rule. If someone violates those, they can be disciplined for those. Employers, if you have teleworking employees, you can require precautionary measures for teleworking employees. That can be changes in their home office. That can be all sorts of other sorts of things to keep them safe while they're working, whether that's on property that's paid for by you or property not. So you can ask them to take precautionary measures even if they're teleworking. I guess, watch out for the dog or, other sorts of things. Make sure that home improvement project is screened off during this time, all sorts of things. This is a difficult one. We've gotten this question a lot. Statistically, people 60 and over are more likely to contract the more serious symptoms of COVID-19. So we've got lots of employers that have said, should we be allowing people in the workplace, and specifically, should we be allowing people in the workplace to have contact with people outside the workplace that we can't control that are 60 and older? Really what the EEOC has come back and said, no, you can't do that based on age. However, there could be, if someone has a serious medical condition, you probably should be making an accommodation for that individual so they don't contract COVID and have a serious or disabling or mortal injury because of that. But you can't do it just simply because of someone's age. So again, this probably goes back to what Hugh was talking about with the FMLA. The ADA, the FMLA is forgiving for families. The ADA is not forgiving for families at all. So work accommodations are only for an employee's disability, not for a family member's disability. So if someone is going home and taking care of a grandmother, or someone is going home and and taking care of someone that's ill or sickly or has that would have a more serious outcome, your work accommodation, the ADA doesn't require that work accommodations are made for that individual who's a caretaker. Employers can make accommodations for telework, modified schedules, all of the different things to help employees with school-aged children. Two of us in the room have school-aged children that need help now or may need help in the future. You can make those accommodations. You should make those accommodations as employers. However, you can't prefer one gender over another, one parent over another. It needs to be neutral for all of your employees because, again, we're looking at discrimination here on more or less favorable treatment. The other part is pregnant individuals can have more serious outcomes from COVID-19. However, employers can't have a policy that excludes pregnant individuals from the workplace. However, if a pregnant individual develops a disability related to that pregnancy, again, just the same as in the good old days of 6 months ago, you can accommodate that disability related to pregnancy.
All right, and the next part of this is that after we all sat down, learned about Dr. Fauci and got Netflix, then the next step appeared to be to order carryout because we got tired of our cooking. Some of us, like myself, realized that we really aren't very good at cooking, and so we needed food from somewhere else, and more importantly, booze, because what else were we going to do while we were in our homes with our families 24 hours a day? So that's what we did. That leads us to that inspired the following slide about your potential liability. So as an employer, you want to understand what would happen in a workers' compensation case. Just as a preview, workers' compensation is the law that says if an employee is injured at work, the employer is responsible for paying weekly benefits and for medical care. Now, the nice thing about workers' compensation is you don't have to pay for pain and suffering, but you do have to pay for injuries that aren't even caused by negligence. And that's the trade-off in that particular circumstance. If workers' compensation didn't exist, you wouldn't be responsible for your employees' injuries unless you were in some way negligent. Workers' compensation says, nope, you have to do that. If their injury arises out of the course of their work, you have to pay for it. Well, so COVID presents an interesting problem in that context because certainly people could get COVID at work. People could also get COVID from the grocery store or from their family members. So there are two principles that you should understand about workers' compensation just in case this happens to you, in case one of your employees gets COVID. The first one is the actual risk doctrine. And in context of accidents under Iowa Code Chapter 85, you can be liable for your employee getting COVID if the nature of their employment exposes them to the risk. And it doesn't matter in that circumstance that the risk was common to the general public. And so what you need to understand about that is I always use the grocery store, the convenience store as the easiest example. If you have someone who has to stand at the cash register and be exposed to 100 different people a day or 1,000 different people a day, you're more likely than not, you are the person that exposed them to COVID, as opposed to what they're doing in their private lives. Same concept applies under occupational disease. Chapter 85A is occupational diseases, and the disease must have a direct causal connection with the employment and followed as a natural incident from the injurious exposure occasioned by the nature of the employment. And that's the concept of that last sentence I think is the most important to you, that a disease that follows from a hazard the employee was equally exposed to outside of their work is not compensable as an occupational disease. The easiest thing to understand in occupational disease is hearing loss. So for instance, if you have an employee that has hearing loss, this is the analogy I always use so people understand it, is that, well, if a person loses their hearing, but your workplace is no louder than their home, you're not liable for their hearing loss. But in a circumstance where you have them work 8 hours a day next to a 100 decibel machine, you're liable for their hearing loss because more likely than not, and that's the standard, that their hearing loss is a result of their employment. So when it comes to what you want to do with your employees, keep in mind what you want to expose them to and what you don't want to expose them to, just in case you have a workers' compensation liability. Next, here's the next. All right. So then we have a
Can I
discussion.
ask a quick question?
Sure,
Yes.
you
A
bet.
question on that. So most of the businesses have not had, obviously viruses weren't covered in their insurance policies, and of course every policy is different. If an employee does decide to sue the owner, it's not technically a disease, would you see any insurance policy that would cover them?
Yes, because if the employer's only right or employee's only right against the employee would be in workers' compensation. And the workers' compensation policy most likely is not going to have an exclusion for occupational diseases because you're otherwise responsible for it. So the employee first, to understand, the employee could not bring a tort action, a claim of negligence or intentional conduct against their employer in the first place. So that particular exclusion for diseases wouldn't apply to prevent coverage under the workers' compensation. But what I think you're driving at, or the other part of it is, the next slide we're going to talk about is whether or not you have reopening immunity. Because a civil action, this is a case in district court as opposed to a case with workforce development. A civil action, there's a law that is going to be codified here at 686D that says that you cannot be sued for alleged exposure to COVID-19 unless one of these things is true. That you have minimum medical condition, death or hospitalization, or all of these things are true. You acted with the intent to cause harm, and your act constitutes actual malice, like you're really trying to give people the disease on purpose. This applies to, and I think this is the exclusion you're talking about, Christina, or that the question was talking about, is the concept of, on the next slide, where we're talking about what happens when people come on your premises. What happens when you invite, and this is really about your customers. What happens when your customer comes onto the premises and claims that they got COVID-19 from one of your workers? Well, that's where the legislature sat down and looked at exactly what the questioner was asking about. It said, well, if you have an exclusion on your policy for giving a disease to another person who's not your employee, how are employers or how are businesses going to open up if they potentially are going to get sued by any person who develops COVID and it was at their place or at their place of business? Because then you'll have that person file a lawsuit that looks something like this. So, the only place that I go is the Hy-Vee grocery store. I got home and I got COVID. I don't go to work. My wife doesn't go to work. My kids don't go to school, and I developed COVID. I must have got it from Hy-Vee. All right. So what the legislature did is said, there's no insurance for causing your customer's disease, because that's usually an exclusion. So let's set up a standard that says if you're recklessly disregard and create a substantial and unnecessary risk to individuals, then you can be liable. If you do it with actual malice, and in the law, actual malice means like, I hate you, I specifically want you to get COVID, and the same thing with intentionally, then you can be liable. Otherwise, simple negligence, like I didn't do a good enough job, can't be liable for it.
And I just point out on 1 and 2, this is really why I would encourage employers to have anybody that has employee-facing, employers that have client-facing employees, so people that are going to meet with clients, that you wear masks or exposing individuals through mouths, that someone that has COVID gets that negative test before they come back to work, because you really, you can get around the reckless disregard, the malice, if you're taking those steps that the CDC, that the Iowa Department of Public Health have told you, OSHA has told you, reduces the risk. It's much harder, even under a difficult standard, to get a lawsuit that goes forward.
And that's what we're telling business owners, is that you can open your business and safely not worry about being sued by your customers if you take some very simple steps. So for instance, as Brent mentioned, the CDC has some guidelines that are, put up plexiglass, make your people who deal with the public wear face masks, those types of things. And if you follow those, you're going to probably win any lawsuit against you. The next slide we talk about just briefly is that The overarching part of this is that OSHA has a general duty of care for people that essentially says that there's a catch-all under OSHA that says that you have to have a generally safe workplace for your employees. And so it's entirely possible that OSHA will come into your place and look at it and see if you're taking care of your employees above and beyond workers' compensation, above and beyond civil liability through lawsuits. And in that circumstance, if you follow the guidelines of the CDC, I think you're going to be okay in that circumstance, but I'm not sure. So the next slide is our Hamilton slide.
So Hamilton. Hamilton was a Broadway musical described by its creator, Lin-Manuel Miranda, as America then as told by America Now. It premiered on Disney Plus on July 3rd, 2020. It increased downloads of Disney Plus by 72.4% during that period of time, which is great news for Disney since they've lost approximately $3 billion in revenue during this period of time, and why my kids are really happy that we're now Disney shareholders. But Hamilton, and here we have King George with his song, What Comes Next? And that's what we're going to end up talking with you about, is what comes next. Well, I mean, in the short term, if you didn't know this, now you know, comply with OSHA, CDC, other local workplace safety or health organization regulations for safety protocols. Do that. Continue to do that. Stay updated. Look at the websites. If you need to talk to legal counsel, talk to legal counsel. Get advised. Stay advised on what those standards are until the pandemic ends. After the pandemic ends, hopefully sooner rather than later, you have to meet with employees to determine which disability accommodations need to remain. And part of that is, do you need to restructure jobs? Do you need to restructure schedules? Do you need to restructure the workplace? Because that's really the next part, is look at adapting the workplace to job duties, schedules, and budgets. Because your budgets may be severe. There may be markets that just don't exist anymore. There may be clients that don't exist anymore because of the shrinkage of the economy. So look at that and look for future pandemic outbreaks. That's something that we've repeatedly been told by the CDC is, yes, this is terrible. Yes, this is going to be long-term and we need to have, but likely this is going to happen more often than not in the future. So look to accommodate your workplace and way your work is done for future pandemics. The final part, I can't stress this enough, is appreciate your employees and all the resilience that's required for all of us to continue to live and work through what's really an unprecedented challenge. So that doesn't mean necessarily handing out bonuses, because you might not have the budget to do so, but tell people you appreciate them and all the work that they've done to keep everything going in the workplace. So that's our presentation for today. We have just a couple of minutes. We're happy to take any questions.
Yeah, so I think we've got about 1 minute left. If you guys are okay with me sharing your email addresses or just one email address, would that be okay if they have questions that they could direct to you? I think there'll probably be specific situations. Are you okay with that?
Yeah, that's great. We're happy to answer questions.
Okay, perfect. I think the one thing, if you could just give just a quick reference to is, I wrote this down because it came up from somebody that couldn't attend. Workers that need to come off of unemployment and come back are now claiming, you plug in the blank of anything you talked about today. Are the employers' hands tied, or is there anything that they can do to make the employees come back if they do not believe the situation is they have COVID or any of the other things that you referenced today? Basically, they're saying, I've called my employees back, now they're claiming that they don't feel safe or they don't have childcare or whatever that may be. Anything the employer can do, or do they have to follow through and let the employees
make sure that they are in compliance with the general safety standards of OSHA? So are they doing CDC stuff? Are they cleaning? Those sorts of things. If they refuse to come back, I mean, the ultimate penalty is they're no longer your employee. They are terminated. That'll get you into a fight as to whether you owe unemployment, and that will be a nasty situation. But I mean, that's the ultimate penalty is if you don't come back, then you're no longer my employee.
Yeah, if the claim is I can't come back because and we've seen this, I can't come back because the workplace isn't safe. As long as you're complying with the CDC, the Iowa Department of Public Health, those sorts of things, I think you have a great defense to the unemployment claim or any other claim that you might not be accommodating people or you might not be doing the things necessary to take care of this individual with a disability or otherwise. So the best advice there is document what you're doing and make sure as an employer you follow through with those regulations and those limitations on what you can and can't do.
Okay, perfect. Well, we will wrap it up today. I will send out, if one of you just wants to respond, if you want all the email addresses or just one to me, that will be great. I will send out a follow-up email to our attendees today. And again, this will be recorded and we will have it out online. It'll be both under our COVID small business page as well as our business resources. So thank you to Hugh, Brent, and Eric for being with us today. And we will see you guys next month at our next Top 5.